Okay, well, good afternoon and welcome to everyone. I'm Jill Fish, and together with Professor Elizabeth Pullman, who you will hear from later, I am co-director of the University of Pennsylvania Carey Law School's Institute for Law and Economics, or ILE. I'm delighted to welcome you today to a really special program, which is part of ILE's Law and Entrepreneurship lecture series. Today's program kicks off, and we've got a lot of surprises today, really rich program. But today's program kicks off with a moderated conversation between Martin Lipton, one of the founding partners of Wachtell, Lipton, Rosen and Katz, and his partner, the extraordinarily accomplished litigator, Ted Mervis. As we all know, Marty Lipton's achievements are many. For over half a century, Marty has combined deep involvement in teaching and scholarly writing with practice at the highest levels. Moreover, it's really special to have Marty at ILE because he's always exemplified ILE's foundational belief that scholars can learn from practice and vice versa, and that we all have a duty to give back to the current generation of law students and to society more generally. To that end, Marty has been a regular feature, not just as a teacher at his beloved law school alma mater, NYU, but at Penn, where he earned his undergraduate degree. I should note, Marty also has a daughter who went to Penn Law and another daughter who went to Penn undergrad. So Marty's ties to Penn are pretty strong. From the 1970s, Marty regularly participated in Saturday seminars at Penn Law for students of then Professor Bob Mundheim. His involvement has continued to the present, where he has consistently enriched the life of Penn Law and ILE. In fact, when ILE itself was formed in the 1980s under Professor Michael Wachtell and Dean Mundheim, Marty gave an important early lecture, packing the house for alumni at the Four Seasons Hotel and at the law school for a separate session with the students. Famously, Marty's known for his willingness to take firm positions on cutting-edge issues, to suggest best practices to improve corporate integrity and effectiveness, and to advance his view of a corporate governance system that is best for society, one that focuses on sustainable wealth creation for stockholders through the respectful treatment of all stakeholders, the environment, and society. And these views are at no time more important than they are, I think, today. We're fortunate to have Marty's longtime partner, Ted Mervis, to lead the conversation with Marty. Ted, as you all know, has litigated many of the landmark cases in corporate law, and we at ILE have also benefited from his active engagement in Penn Law programs. But enough from me. Before I turn the program over to Marty and Ted, just one logistical note. If you signed up for CLE credit, we have 2 CLE words that will pop up on your screen during the program. You need to write them down and you need to submit them with your CLE evaluation form. And now, with no further ado, let me pass the baton to Ted and Marty.
Well, thank you very much, Jill, and thank you for this opportunity to get that to go away. To an opportunity to ask Marty questions that I've been burning to ask since I first joined the firm 45 years ago. So I'll start at the beginning with an easy one. After you graduated from Wharton, Marty, was going to law school a no-brainer for you?
Well, I'm not sure it was a no-brainer. What happened was I graduated in 1952, having been turned down. I failed the physical exam to get my ROTC commission. I thought I'd like to be an investment banker. That was my father's ambition for me. Of course, in 1952, there weren't that many openings for investment bankers. I grew up in New Jersey. I knew of, I didn't know him, but I knew of Arthur Vanderbilt, who at that time was no longer the dean of the NYU Law School. He was then the Chief Justice of the New Jersey Supreme Court. Sort of as a last minute, and it was pretty much that decision, I decided that since I couldn't get a job as an investment banker, maybe I could get a job as a lawyer if I went to law school. And that's how it came about. It was not a burning ambition of mine. It was sort of, well, that was something that I had always sort of considered, but had shifted emphasis to investment banking, and now that didn't work out. I applied, I got admitted, and as sometimes happens, early on, I realized that this was something I really was interested in, really liked, and I worked hard at it. And one thing always leads to another. When you're working hard at something, you get the opportunity to take the next step, and that's what happened. I found that I had sort of found my ambition was to become a lawyer, and I worked hard at it, and I did well at law school.
Indeed, it was at law school, as I understand it, where you were editor-in-chief of the Law Review, where you met your future partners and founders, Herb Wachtell, Len Rosen, and George Katz.
Yeah,
And
well,
Herb
you get lucky sometimes. Much of one's life, when you look back at it, is really a series of events that were unplanned. They just happen. One thing leads to another, and Herb Wachtell and Lenny Rosen and George Katz were a year ahead of me at the law school, and they were the senior editors when in my second year I joined the Law Review staff, and got to know all three of them. I got to know Herb, who was the notes editor, better than Lenny and George, but all three. Herb, of course, edited the first thing I wrote for the Law Review, and to this day, he has the same typewriter. He had one of these old manual typewriters that sat on the desk, and he could type, I don't know, over 100 words a minute on that typewriter, and insult me every 10 seconds for my stupidity in the draft of the note. I refrained from hitting him. We became friends and have been ever since. And law school was good for me. I made good friends. I kind of discovered what my interest would be. I had a very interesting professor for corporation law. And at this time in 1953, 1954, proxy fights had come into vogue. And while taking the corporation course, the Robert Young fight to get control of New York Central Railroad from the Vanderbilt family, not the author Vanderbilt family, but the Vanderbilt family that established the New York Central Railroad took place, and we followed that proxy fight rather closely in the corporation's course. And when it came time to think about what I would do after law school, the then dean, Russell Niles, called me into his office and he said, you know, you've done very well as a student. You've done well as the editor-in-chief of the Law Review. I think you would make a great law professor. And I've determined that NYU should grow some of its own. I would like you to, first he said go to Yale. He had been a sterling fellow at Yale. And I said to him that, well, I'm really interested in corporation law. Is Yale the right place to be? And he said, no, I think if you're interested in corporation law, the right place to be would be with Adolph Burley at Columbia. And I'll see if I can arrange something at Columbia, if that you're willing to do that. And that's how it all came about. I said yes, and I ended up with a teaching fellowship and Adolph Burley for a thesis advisor and sort of mentor. Burley had really invented corporate governance and what I'll call corporate law with his early writings, The Modern Corporation and Private Property with Gardner Means in 1932, and at the same time, a dueling set of law review articles with Merrick Dodd, who taught corporation law at Harvard. And what transpired in the 31 to 33 period was the invention of stakeholder corporate governance and shareholder primacy corporate governance as a result of the duel between Merrick Dodd, who said that the purpose of a corporation is to serve all of its stakeholders. The government enables incorporation in order for corporations to serve the interests not just of stockholders, but of employees and customers, and especially the communities in which it operates. And at that point, in 32, Burley was sort of a shareholder primacy person, in that his point was that the founding families of the great American industrial corporations had basically been replaced by professional managers, and the law should strengthen the hand of the shareholders to control the professional managers. And not too long after he left for Washington with Franklin Roosevelt to be one of the stars of the brain trust for the New Deal. And he was the author or the contributor to much of the New Deal legislation. which if you step back from it, much of the New Deal legislation was really stakeholder corporate governance. In any event, by 1955, when I showed up in his office, he was heavily committed to stakeholder governance and assigned me as a thesis topic. And I have to admit, I didn't quite understand even what he was talking about, but it was what impact the creation of mutual funds and pension plans was going to have on corporate law. And that the accumulation of shares in the hands of pension funds and mutual funds would give voting power to asset managers and institutional investors, and how did corporate law adjust in light of that concentration of control. Well, I got my comeuppance. I tried pretty hard, wrote some memos and so on, but certainly did not grasp the full extent of it. My year was up. I had turned in my memos. I hadn't really started a thesis at all because I couldn't quite figure out exactly how to approach it. The closest I came was that the shareholders might be deemed to be control people and then have special duties to the corporation because they had control. Anyhow, it didn't constitute a thesis, and it wasn't the way the law went. Another professor at Columbia, Herb Wexler, another great star, was friends with Judge Edward Weinfeld, the Southern District Court, and Wexler said to me, "You ought to take a clerkship with Weinfeld. He's looking for somebody, and I'd like to recommend you." I had, as part of my teaching obligation, I taught the terminal law course with Wexler, and that's how I had gotten to know Wexler. In the event, I did clerk for Weinfeld and kept the contact with Niles during both the time I was at Columbia and clerking for Weinfeld. And Niles had said to me, "If you're going to come back here to teach corporation law, you need a few years at a corporate law firm here in the city." And as things worked out, I had been a summer associate for a firm, Seelix and Morrison Newberger, in 1955 on my way to Columbia. I ended up joining that firm when I had finished the clerkship. And while I was clerking for Weinfeld, Lenny Rosen got discharged from the Army. He had gone in after law school, and was looking for a job. And I said, well, I've disappointed this firm. He knew Professor Seelkson also. And they have been looking for somebody. Why don't you see them? And I arranged for him to see them. He got hired. And so he was there. I finished the clerkship. I went to Seelkson Morris, Newburger. And just weeks after I started, I went to a reception at the law school and saw Niles, and he asked me what I was doing, and I told him what I was doing, and I mentioned that I was working on an SEC registration statement for a small oil company, and stuck in his memory. A couple of days later, I got a call from him to say that Chester Lane, who was once general counsel of the SEC, had died. He taught securities regulation at NYU. I had taken the course, and Niles said, since you took the course, I have his class notes. You can pick them up. You're teaching it, I forget whether it was next Wednesday or next Thursday. And then he ended with, and don't worry, Marty, next week I'll have somebody who knows how. So for the next 20 years, I taught securities regulation and from time to time corporate law on an adjunct basis, and stayed with the Seelkson firm 1963, the end of 1963. George Katz joined us. Lenny and I induced him to leave the firm he was with and come with us, more for friendship than for business, but it was basically three friends getting together. Lenny and I had been working with Herb Wachtell. Herb had been a U.S. attorney. He and I were in the courthouse at the same time. And he left the U.S. Attorney's Office, established a two-person firm. Lenny and I had been referring litigation work to Herb, and when the Seelkson firm dissolved, the end of '64, sort of on a catch and catch can basis, we said to Herb, well, maybe we'll share office with you. And frustrating experience looking for space. And one day, and now the stories diverge. Herb remembers that,
Herb has a different version, I know.
Herb remembers that this took place in a horn and hearted automat. Of course, it actually took place in a broken down, empty law office in one of these buildings on Lexington Avenue. When the four of us were there together looking at space and getting discouraged, and got into a conversation of, well, instead of sharing space, why don't we just form a firm? And spur of the moment form the firm. So you can get Wachtell's version directly from him if you want, but
I've heard it many times.
The true version.
Yeah.
In any event, that's how it all came about. January 1, we began practice.
What were the basic principles for the firm from the beginning?
Well, the basic principle was really just two. One, we shook hands, and remember, we were close friends at this point. And we just said, look, we'll always be equal partners. We'll never have any contention, you know, and we'll just run it together. And I don't know that the conversation was more than that. Herb said, yes, I'm convinced that if you do a great job, clients will beat a path to your door and will do just fine. And I said, well, Lenny and George and I have $110,000 coming to us from the dissolution of the Seelson firm. So if they don't beat a path to our door, we have enough to last for a year. And that was it. We all crowded into the office that Herb had down on Broad Street. And took us, I don't know, 3 or 4 months before we were able to move uptown. And we did okay. We did okay. What happened is the dissolution of the Seelson firm left some of their clients kind of without counsel. Lenny had been very close to the Walter Heller Company, a commercial finance company, and they turned to Lenny for some things. I had worked with Lincoln Morris, who was really the key partner of the firm, and he had the key corporate accounts. And not all of them, but most of them came with us. So from the very beginning, we were off and running. We had more to do than we could handle, really, from the day the door opened. And it progressed. By the end of the first year, we were seeking help. We went to our friends at NYU and managed to get an associate. And sort of it just marched along 65, 66, 67. And the practice grew, and by 69, I would say we were sort of established. We were at that point, I think 8 or 9 lawyers. Maybe we had gotten to 10, but and then things changed rather dramatically. And what I said about chance comes into play here. I grew up with a person named Melvin Seaton. We lived on the same street. Our fathers were friends. So on. Mel went off to Harvard. I went off to Penn. We hardly saw each other thereafter until one day, 1965 or so, we ran into each other in the lobby of an investment bank, call them Loeb Rhodes, and said, we have to get together. So on. It was 2 friends lost touch, so on. And Mel had started a firm called Seaton and Takeovers, and with 2 partners and 4 or 5 associates, a investment management, somewhat brokerage firm, and the they they got into a lawsuit, and unbeknownst to me at the time, Herb Wachtell was in the same dormitory as Mel Seaton. Mel had gone to Harvard Law School, but did not practice law. Went to Wall Street immediately on graduating. In any event, got a call from Mel saying that he was very troubled by a lawsuit that had been started against him. And I said, "Oh, I'd be very happy to help you." He said, "No, Marty. No, I'm not calling you. I want you to get your partner, Wachtell. He's the smartest person who ever went to the Harvard Law School. And I want him to represent me. I know I checked on the litigation work he's been doing." And Herb got the case dismissed, and Mel and I reestablished our friendship. And Mel was really big time. DeQuavis was a great grandson of John D. Rockefeller, and they had interesting clients and connections. And one of Mel's connections was with Solomon Brothers and a partner there by the name of Ira Harris, who had basically become the head of the mergers and acquisitions department at Solomon Brothers. And Ira was one of the great stars of the 70s and 80s M&A experience and development.
Before we get too far ahead, sometime in the late 60s, you created the Marty memo, the typical one-page to our client memo that ranged in subjects from the plumbing of securities regulation to commenting on important decisions, important developments in the marketplace, and taking, pretty assertive positions sometimes on various developments. How did you come to create the idea of the To Our Clients memo?
Well, Mel Seaton and DeQuavis, along with another brokerage firm, was the basic real progenitor of it. The SEC was pressuring firms at that point to stay up to date on SEC regulations and so on. And on inspections, they asked to see what firms were doing. And Mel asked that we try to keep them up to date. And I was teaching securities regulation as an adjunct, as I mentioned, and I started to write these memos, and they became popular. Mel would share his memos with others, and then people in the business asked whether they could be on the list to get the memo, and then every now and then somebody who got the memo called and wanted advice and so on. And the memos actually enhanced our standing as lawyers focusing on corporate and M&A matters and proxy fights and such. And that's how it all came about. I don't know who, I think Leo Strine is the culprit on calling them Marty memos. I never heard Marty memo until Leo joined us. But it,
Okay, but point taken.
but the memos became part of our culture. That we saw things that we didn't like, and we commented on them. We saw things we did like and commented on them. And we tried very hard to help our clients deal with what was at that point a very rapidly adjusting world of investment banking and securities trading and such. And it led to connection with the New York Stock Exchange as such. We actually became counsel to some of the floor trading firms at the New York Stock Exchange. And it was a key relationship with the firm through the 70s and 80s.
And during this time, well, your fellow founders credit you with focusing the firm on the emerging world of takeovers and proxy fights. Did you do that as a form of entrepreneurship, or how did that come about?
Well, like everything else, chance was involved. One of the clients we inherited was a company that became the Metromedia, headed by an entrepreneur named John Kluge. And Kluge had to buy something at least once a month, finance it, and sell something every now and then. Did a lot more buying than selling, and a lot more financing than selling. And so they were our major client early years. And then another of the companies that we continue to represent was called Pepsi-Cola General Bottlers, not the Pepsi-Cola company. They had the bottling franchise for Pepsi-Cola, pretty much solid in the middle of the country, running from Chicago to New Orleans. And here's where Mel Seaton comes in, and Ira Harris. Mel Seaton calls me one day and says that his friend, I didn't know Ira at this point, Ira Harris at Solomon Brothers, heard that Pepsi-Cola General Bottlers was prepared to do a deal, be acquired. We had defended them against 3 hostile takeover attempts and had been successful in defending them. But the board had really said they had it. They didn't want to go through that again, and they were looking for a deal. And Mel induced me to meet with Ira Harris, who had a client who was interested in acquiring Pepsi-Cola General Bottlers. And this was 1969, I guess the summer of 1969. In any event, by January of 1970, Illinois Central Industries, the holding company for the Illinois Central Railroad, had acquired Pepsi-Cola General Bottlers And Ira Harris and I had become close friends through all the work we did on getting that deal done. And the deal ended up with our gaining Solomon Brothers as a client and Illinois Central Industries as a client. So we graduated, still small, but graduated into the big leagues. And it was clear that the key to the big leagues, as far as we were concerned, were proxy fights and mergers.
And I think it's fair to say that the firm became more associated over time with takeover defense than making unsolicited bids. And of course, that set up the paradigm that everyone talks about of Marty Lipton and Joe Flom. But what was your relationship with Joe Flom?
Well, I knew Joe. It dated back to my clerkship with Judge Weinfeld. Barry Garfinkel, who was my predecessor as the judge's clerk, and in fact, his predecessor had joined Joe Flom's firm. So Barry Garfinkel recruited me to join Joe's firm. I was not interested, having basically all along intending to go back to the Seligson firm, where I had been the summer associate, where Lenny had gone. And so I knew him, and I kind of followed what they were doing, particularly because of Barry. And when we got involved in some transactions or proxy fights, I ran into him maybe once or twice a year, going forward into the early 70s. I mean, I wrote a book review, 1972 or 1972 or 3. One of these long book reviews for Law Review, in which I said, the first question an arbitrateur asks is, which side has him, referring to Joe Flom. Joe had developed the reputation of being the lawyer to go to in proxy fights and in hostile takeovers. And he had developed relationships with Morgan Stanley and Lehman Brothers, most of the major investment banks. And in 1974, which was really the year in which we became significant in terms of tender offers and proxy fights. We represented Lowe's Corporation in a hostile bid for the CNA insurance company. Flom was not involved, and we were successful. Wall Street all thought we were not going to be successful, but we were successful. And the interesting thing is that as a result of it, really a number of different things that took place all within the space of less than a year. Our success in the Lowe's CNA, Joe Flom represented the International Nickel Company, Inco, in a hostile bid for the electric storage battery company, ESB, where the investment banker for the raider, Inco, was Morgan Stanley. And it was the first time where a major investment bank like Morgan Stanley led a hostile takeover of a long-established company like electric storage battery. And it sort of set a whole new outlook on tender offers, and the whether they were appropriate or not. And it ignited a great increase in tender offer activity, scrambling for both service in making tender offers and serving in defense against a hostile takeover. And the Lowe's CNA matter was so heavily focused on by Wall Street and was, in their view, impossible to win. It just sort of brought clients to us. And within weeks after it was over, starting in 1975, at least a half dozen of the major Wall Street firms. Now, the only Wall Street firm we had any connection with at that point was Solomon Brothers. Solomon was the banker on the Lowe's deal. But Goldman and Dillon Reed and Lehman, came to us kind of as experts. There weren't that many law firms that had the kind of experience we had. Flom was the dominant lawyer in the field. And of course, if he was on one side, they needed somebody on the other side. And which led to Clay Felker, the editor of New York Magazine, assigning Steve Brill to write a story about these two tough lawyers in the takeover game. And,
Right.
and that article, of course, made the rounds of all the investment banks and public relations firms and so on. And pretty soon, it was true. There were two tough lawyers in the takeover game. And,
Of course, I'd just like to focus for a minute in conclusion. You and Joe Flom were not only the leading M&A lawyers, but you were both law firm innovators and stewards. Skadden Arps obviously grew in a much different direction, opening many offices, expanding into many practice areas, while Wachtell Lipton, I think it's fair to say, on four important objective issues was different. We've always been a one office firm. We've always tightly concentrated on business law. We, for the most part, kept a relatively low ratio of associates and partners. And fourth, instead of opening other offices, we've allied ourselves with leading law firms in cities across the world, including in Delaware. How did you come to make these decisions at a time when not only Joe Flom, but many of your New York peers were taking their firms in different directions?
well, frequently I give the short answer and say fear. We never thought that we were that good, that we could manage more than we had. And we were never prepared to take positions that we were uncomfortable with. And I guess
That's
more
also,
than
I think,
more than anything else, we really enjoyed our relationship, and the relationship that built up over the previous 10 years with the younger people who'd come in, and we consider ourselves a family. And we refer to ourselves as a family. We still refer to ourselves as a family. And so we sort of felt that we were doing what we wanted to do. We were doing it well. We weren't looking to make more money or grow in any way. We just were happy to do what we wanted. And at that time, a couple of other things happened. The W.T. Grant Company went bankrupt. Probably the biggest non-railroad bankruptcy that had ever taken place. And Lenny did a fabulous job on that. The city of New York started to sink towards bankruptcy. And Lenny Rosen and I started to advise Jay Golden, the controller of the city, with respect to both bankruptcy and securities regulation issues. We ended up as special counsel to the city in the fiscal crisis. We represented the city in the bond issues and all the agreements that solved the fiscal crisis. We met Felix Roden, who was the key partner at the Lazard Bank, and worked with him through 75, 76, 77, and dealing with the city issues, and then became a principal law firm to Lazard. And it all sort of, again, coincidence and chance, all sort of fell together. And as these things piled on, we grew bit by bit. We had all sorts of kind of offers to merge or join, and we never even paid attention. You know, if somebody said it to us, we said, no, we have absolutely no interest. For the city fiscal crisis in the 2 months, November and December, every single person in the firm worked not 24/7. They worked 18 or 19/7 for 2 solid months, with somebody going to Washington and virtually living with the Treasury and IRS to get rulings that were necessary. Others going to Albany to get legislation that was necessary to protect the trustees of the pension funds. And I slept on the wooden bench outside of the Blue Room in City Hall night after night. It was one of those times when basically we had to get everything in place by December 31, and we did. So we had a camaraderie and a relationship that was very, very special. And to this day, we don't want to disturb it. We've been very fortunate in the people who have joined us. They bought into the family in the sense of accepting the principles we work under, and it's a great life. And I think most, some people didn't like it. They left early. They were with us for 3 or 4 years, and they said, "This is not for us," and left.
I would just say in closing, to me, I would put it in one sentence from my own perspective. Since I started the firm, was a latecomer, started in August 1977, but not for a minute have I ever felt like I worked at Wachtell Lipton. I've always felt, and I think it's true of all my colleagues, we always felt that we were part of Wachtell Lipton, not that we worked there. And I know you've resisted calling yourself an entrepreneur, and today you've attributed much of the firm's success and your success to chance, but I don't want to argue with that, but I'm hoping you would at least agree that others might see the firm that you created with Herb and Leonard and George, and that you continue to mold is a very special and unique place that I and many others on this program and who will one day watch this on tape have benefited from and look forward to being a part of for a very, very long time. That's what you call a rhetorical
I certainly
question.
hope so. I certainly hope so. And we did and do intend that it be a place of our liking and not of what others think law firm should be. As you know, and as most people know, we encourage our people to teach, and many of them do, on an adjunct basis, 1 or 2 courses. I sort of stopped it for a long period when I was chairing the university board, but as soon as I stopped chairing the university board, I went back to teaching a course in the law school. And we encourage everybody. We view ourselves as maybe the best is a stakeholder law firm. In other words, we are stakeholders in the community. We are stakeholders in the legal profession. We are stakeholders in education. We are stakeholders in healthcare. And I don't think we have a partner who doesn't devote some substantial time to either philanthropic activities of one kind or another, educational activities, promotion of healthcare, promotion of human rights, and dealing with inequality and so on. We've never held ourselves out as pro bono lawyers. Never really believed in pro bono lawyers. Time and again, we will take on a case for an indigent defendant. Within the last year, we rescued somebody from life imprisonment who was not guilty. We've done that consistently. I've always felt that our pro bono activity ought to be the things we do best, and we should support the organizations that do it professionally and have really very good people at doing it, and that's how we focus. But it's the rare person in the firm, including associates. We encourage associates to get involved. We have a foundation that we contribute to each year to support the organizations that we work with for societal purposes. It's again, much of this relates to Arthur Vanderbilt, because Vanderbilt believed and established the modern NYU Law School on the basis that lawyers owe public service, that that it is part of the legal profession that lawyers be involved, not just in representing clients for a fee, but representing people who can't afford a fee and contributing their services to philanthropic and societal organizations, and making sure that the judiciary functioned appropriately, remained independent and committed to the rule of law and such. And Vanderbilt, even when he was Chief Justice, would come several days, really evenings a week, to meet with the people who had Root Tilden Scholarship, something that he had promoted to encourage people to go into public service. And he would talk about his own career and how he had devoted so much time and effort to things in New Jersey, and he established the Institute of Judicial Administration, which is IJI, which continues as a major organization today. Much of the NYU Law School is attributable to his start, what he conceived of as a modern law school, and one that would focus its graduates not just on practicing law, but on being part of the part of society and contribute to society in every way. And I think that stuck with us, and I think it has really run through the veins of the firm from the beginning, and that's the feeling you described as being part of a family, not as being an employee or a working partner, but actually somebody who's a member of a family that does more than just practice law.
Well, thank you. Thank you again for sharing all that with all of us and personally with me. And with that, let me throw the program over to Professor Pullman, who is the co-director of the ILE. And thank you again.
Thank you so much. As Ted mentioned, I'm Elizabeth Pullman, a co-director of Penn Law's Institute for Law and Economics. And on behalf of ILE, I want to thank Marty Lipton and Ted Mervis for the time and effort they devoted to preparing and sharing the fascinating conversation we just heard. As that conversation reconfirmed, Marty Lipton is an iconic corporate law thinker and practitioner, universally respected by corporate law scholars, corporate lawyers, business leaders, regulators, and judges for his innovative contributions to corporate governance. And perhaps most of all for his unflagging belief that corporations must conduct themselves in a manner that's respectful to all their stakeholders, particularly their workers, and that's good for society. But when I say that Marty is universally respected in the corporate law community, you don't have to take my word for it, because we're about to hear from a distinguished group of speakers, each of whom will briefly attest to Marty's importance to the development of corporate law. And we begin with some words from Marty's partner, fellow firm founder and friend, Herbert Wachtell.
I understand that this tribute to Marty includes recognition of his incredibly impressive body of legal and policy writing over the years. So I am here to say that I was there for the very first. A few decades back, I was decisions editor of the law review at NYU Law. Marty was a second-year aspirant who had the fortune, good or bad, to have me editing his recent decision paper. We must have gotten along well. He obviously showed talent even back then. We made him editor-in-chief, and the rest is history.
I am a fan of Marty Lipton's. Marty is an intellectual leader in corporate law. What impressed me most from the days I started in law teaching in the early 1980s is not only that you had to read Marty's commentary, including his firm memos, to understand contemporary issues in corporate law, but also that he deemed it important to integrate corporate law practice and scholarship for his clients, courts, and policy debates. Marty read and assimilated seamlessly into his legal practice and the ethos of his law firm, issues and arguments raised in the academic literature by both legal and finance scholars. His memos commented on work with which he disagreed, as well as agreed, never fearful of taking a stand. Speaking from experience, as well as from conversations with other academics, it was a thrill to be discussed in one of Marty's client memos. The appeal of the memos were that they were pithy and succinct, explaining the relevance of even the most technical research in relation to corporate law. Marty's contribution made the dynamics of corporate law scholarship starkly different, and for the better, from the rest of the legal academy. As the field was actively engaged with the real world, it also made it interesting and fun. It is not possible to think about corporate law, any corporate law debate over the past 40 years, the length of my academic career, without Marty's name being prominently mentioned. Indeed, one would be hard-pressed to make sense of the vast changes that have occurred in corporate law over this period without acknowledging his pivotal role in those developments. This is not to say that I have always agreed with what Marty had to say, but to acknowledge that all of us have benefited from Marty's perspective as he immeasurably improved the quality of discussion. In the US, we don't use the term national treasure as do other nations such as Canada and Japan. But if we were to adopt such a convention, I have no doubt that Marty would be universally recognized to be one of those rare individuals.
When the takeover boom hit, corporate law was in flux, and it was Marty Lipton who developed and popularized innovative approaches by which new conflicts of interest and other issues raised by takeovers could be addressed within the sound traditional framework of Delaware corporate law by focusing on integrity, a quality deliberative process, and the use of engaged independent directors to check conflicts of interest. Marty encouraged Delaware to enhance its corporate law to meet new challenges in a credible and effective way, one that has continued to work effectively to this day to confront the new challenges of the 21st century.
Marty Lipton is an academic who somehow got diverted into practice on his way to the academy. Like a great academic, he understands that the creation and dissemination of knowledge is centrally important. Law review articles are one way to do so, and Marty's law review articles have been seminal, but only one way, and not necessarily the most important. So too is taking a leading role in the great corporate law debates between judges, lawyers, and academics that define our field. While Michael Wachtell and I ran Penn Law's Institute for Law and Economics, Marty was incredibly generous with his time, especially, but not only, while Samantha was an undergrad at Penn. Marty's vision of enlightened managerialism, in which managers have the discretion to manage companies for the benefit of all, remains as important today as when he first began articulating it in the 1970s and 80s.
What Marty has done is to identify not highfalutin theories, but practical ways of solving problems in takeovers, in financial markets, and in business that have fundamentally changed how they operate and behave for the better. That is a remarkable achievement, of which us mere academics can only be in awe.
From the early days of the world of mergers and acquisitions, this goes back, I don't know, 4 decades, maybe 5 decades, Martin Lipton was at the forefront. He was the architect who designed much of today's practices when it comes to mergers and acquisitions. All advice, all tactics emanate from Martin Lipton's genius. It would be fair to say that Martin Lipton is the Magnus Carlsen of the world of mergers and acquisitions.
One of my first meetings with Marty Lipton was when he delivered a keynote lecture at Fordham about 25 years ago. The lecture was entitled Corporate Governance, Does It Make a Difference? And for an academic, it was something of a call to arms. I have spent the past 25 years trying to evaluate when and how corporate governance makes a difference. At the same time, I've been observing how much of a difference one person, Marty Lipton, has made in corporate governance. From takeover battles and activism to shareholder empowerment and now stakeholder governance, Marty Lipton has shaped the dynamic and set the terms of debate in the courtroom, the boardroom, and the classroom.
I first met Marty Lipton when we served on a committee together about competitiveness during the Clinton administration. From our talking together, we came up with our 1992 article called A Modest Proposal for Improved Corporate Governance. Our thesis was that corporate governance could be improved by empowering independent directors to work together and constraining the domination by the CEO. We were talking about smaller boards, all independent committees, independent directors meeting without management. It was all simple, basic, practical ideas without any need for new legal rules. These ideas later found their way into Marty's work on exchange listing requirements following the financial crisis. We continue to talk about how boards can be improved, and I believe that with Marty's big brain, his new ideas are going to have a big impact on corporate governance.
Delaware corporate law wasn't ready for the hostile takeover wave of the 1980s. Confronting a surge of Schumpeterian creative destruction, Marty Lipton channeled Edward Burke's defense of existing institutions in the face of the French Revolution. As both a lawyer and a scholar, Marty presented a coherent picture of corporate governance that respected the value of tradition, but with the flexibility to proffer a new paradigm when conditions changed. This was no small contribution. At a time when the term conservative has become something of an empty vessel, Marty's principled position with respect to the board of directors' role has kept the ongoing Delaware corporate law debate both productive and civil.
Having served as a Delaware judge for almost 3 decades, I witnessed firsthand the impact of Marty Lipton's scholarship and advocacy upon U.S. corporate law. Because of Marty's insight and ingenuity in transactional planning and analysis, for me, hearing and deciding cases where his counseling was at issue was always an envelope-pushing challenge. Even so, we Delaware judges could always count on Marty and his colleagues to make presentations on which we could rely for their factual and legal integrity, whether or not we agreed with their position. And I can personally attest that Marty's writings and thought leadership were inescapably illuminating to me and my colleagues on the bench as we dealt with the ever-evolving corporate law and were called upon to decide complex cases in ways that would be sensible for corporate lawyers who were tasked with advising their clients. I have no doubt that that will continue to be the case for the current generation of Delaware judges and for those yet to come. It has been an honor to know Marty both professionally as an icon and personally as an approachable human being, and to witness his remarkable contributions to the development of national corporate law.
I met Marty more than 50 years ago when I was a professor at Penn Law School and have always admired his creativity, depth of knowledge, and thought leadership. Although the demands of his practice and building a great law firm were enormous, Marty continued his interest in teaching and writing about emerging issues in the law. He taught a regular course at NYU Law School and even found time on some Saturday mornings to travel to Philadelphia to participate with other leading Washington and New York lawyers like Art Fleischer, Stan Sporkin, Alan Levinson, and Len Lyman in a seminar on securities law that I taught for a number of years at Penn. Former students still tell me today that with the participation of lawyers like Marty, this seminar was the most valuable course that they took at the law school. Marty also became an invaluable partner for Art and me in making the PLI Annual Institute on Securities Regulation an elite forum for leading thinkers from practice, the bench, government, and the academy to discuss together developments in the law and proposals to improve its effectiveness.
Marty and I have been intellectual adversaries, regularly expressing over the past 2 decades opposing views on fundamental corporate governance questions. Marty put forward forceful critiques of my work in 3 major law review articles, in several oral debates he and I had, and in an impressive number of Wachtell Lipton client memoranda. The challenges of engaging with his critiques and his ideas and the philosophy behind them substantially contributed to my own work. The exchanges between us also contributed, I believe, to the field's understanding of the issues and of alternative approaches. Throughout, I very much admired Marty's commitment to devoting considerable time to policy writing and intellectual thought leadership. I look forward to continuing to engage with Marty and with his arguments and ideas.
Martin Lipton has long believed that corporations are more than just bundles of assets that can be broken up and traded back and forth and reconfigured like properties in a monopoly game. In my first book on corporate governance, which I published in 1995, I argued that if corporate law were to insist that boards of directors and management must maximize share value at all times, this could undermine other important ways that corporations create value. This was not a popular view in academia at the time. But Martin, together with Theodore Mervis and Stephen Rosenblum, gave me great encouragement when they reviewed my book for NYU Law Review. And in that review, they offered their own view about what boards of directors must do. They said, quote, corporate directors must balance constantly the needs and objectives of a wide range of corporate constituencies. A few years later, my colleague Lynn Stout and I developed a model of the role of boards of directors, which offered a game theoretic rationale for exactly this proposition. In the years since, Marty has continued to make the case that corporations must be good citizens and corporate governance must pursue the best interests of society, workers, and the environment, not just investors.
How many people are known by one name? There's LeBron, there's Barack, there's Sting, there's Yoko, and there's Marty. How many people have built a reputation of intellectual consistency, of integrity, and of real intellectual depth while engaging meaningfully with scholars for decades? I mean, who invented the poison pill? Who's done more to promote a stakeholder perspective on corporate governance? And who's done more to integrate corporate scholarship with corporate practice? At that point, there's really only one. There's only Marty.
I want to welcome everybody back and close out the program with one
Do I
very,
get a chance to say thank you, Larry?
sure, take a minute.
Okay. I'm quite bowled over by the ending, and I do want to thank you. I want to thank the Institute for Law and Economics and the Law and Entrepreneurship project, and all that you and your colleagues, friends of long standing, have done at University of Pennsylvania Law School, the Carey School of Law. I was going to say I'm kind of left speechless. I'm not, obviously not speechless, but I am spinning. Thank you all. And I do want to say a word with respect to Delaware and the Delaware judiciary, the Delaware Chancery Court, and my deceased colleague and current colleague, both of whom served as Chancellor Bill Allen. There's no, I'm sorry. There's no court, there's no set of judges who have done the job that they have done in creating a judicial solution to the kind of business and social problems that our current economy creates. And we all owe a great debt of gratitude to both Leo and Bill for all that they have done.
Marty, I've got one more surprise for you, if you'll indulge me for a couple minutes. We have the privilege of rolling out today a new educational resource, which complements our existing Delaware Oral History website. And from our work on that website, it's obvious that some people are more influential than others. And as a result of that, it's our privilege to launch today what we're calling the Lipton Archives, which is a website that we'll be hosting, which contains all of those so-called Marty memos, all of the scholarly articles, all searchable, also articles responding to yours, and lots of other narrative and visual material. I want to take the opportunity to roll a tape, which will give people a brief idea of what's on the site. So if we can get that on the screen, it'll just take a few more minutes.
Imagine, for example, that you were a student who wanted to understand the origins of Marty Lipton's deep beliefs in stakeholder governance and how he first translated those beliefs into a coherent statement of legal principles. If you go to the early years part of the narrative material, you'll see the story of the McGraw-Hill takeover defense and the influence that Harold McGraw had on Marty's developing view that corporations meant far more to society than just the delivery of profits. If you then follow the story through, you'll see how Marty's iconic takeover bids in the target's boardroom flowed directly out of that specific takeover battle. In that same section, you would also find links to key voices taking a different perspective than Marty, folks like Easterbrook and Fischel, and an op-ed they published in 1981 in the New York Times. Likewise, if you are a professor trying to understand the reason why the poison pill was developed, you can go to the early years narrative again and find why Lipton's frustrations with other available defenses led him to develop something that was at once more powerful in that it could block a bid, but less harmful in that it did nothing to devalue or leverage up the company. If you want to see Marty's famous memo decrying decisions of the Delaware Court of Chancery, forcing boards to redeem a poison pill, you can search his memos for the term interco and pull up that memo. More recently, if you wanted to study the corporate purpose debate, you can go to the narrative sections on that and use the memo sections to find Marty's many incisive comments on this debate. So, for example, you'll be able to access the important new paradigm framework Marty developed for the World Economic Forum, which is designed to encourage institutional investors and companies to work together to focus corporate governance on sustainable wealth creation through the respectful treatment of workers, other stakeholders, and the environment. Not only that, you'll see coverage of the active debate between Marty and allies like Lynn Stout and Margaret Blair as they discuss the best system of corporate governance with stockholder advocates like Lucian Bebchuk. By way of final example, if you're a corporate law professor wanting some human appeal in slides for classes, you can find a picture of Marty with his friend Joe Flom, arguably the two most important corporate lawyers of the post-war era. Or in a picture meaningful to Marty, the Protect the Pill hat done by the Wachtell Lipton team to commemorate the firm's win in the landmark pill case, Airgas.
Marty, there are a lot of people to thank for this this creation, this archives, which I think will be an important resource going forward. But I'd like my colleagues to put on the screen a list of those who have contributed, just so you can see who's been involved. And once we take a look at that, I'm going to take the privilege of closing out the program with very sincere thanks, gratitude to Ted Mervis, to David Katz, to all your colleagues at Wachtell Lipton for helping create this site, to Leo Strine for driving this project, and most of all, Marty, to you for all you've done for corporate law, for Penn Law School, as well as NYU, and for this particular program today. I want to, as I said, note thanks to all the folks listed on this slide and wish everyone a very good rest of the week and weekend, and look forward to having your comments on the archives as we go forward and integrate ever ongoing continuing submissions by Marty to the growth of the website. So thank you all, and I appreciate your attendance today.